Hello, I'm George Liston, CA. Welcome to Dialogue, a program that explores the world of ideas and issues in international affairs, history, and culture. The Supreme Court of the United States of America is more than a principal institution of American government. It's also a prime repository of the faith of the people in that government. Throughout American history, the court's decisions have, for good or ill, spoken directly to the landmark issues of this society's evolution. For that reason, it has and it will touch the life of every American citizen. The court is itself a living entity, changing as individual fate and social destiny bring new challenges to its members. But rarely in its history have events conspired to produce a judicial moment more fraught with drama than this autumn of 2005. The death of Chief Justice Rehnquist, who presided over the court for nearly 20 years, and the imminent retirement of the woman considered the most influential justice would alone make this an historic moment. But there is also, of course, the court's agenda and the issues rising on the horizon, which add to the potential for a session of uncommon significance. My guest is Joan Biskupic, Supreme Court correspondent for USA Today and author of Sandra Day OConnor, How the First Woman on the Supreme Court Became Its Most Influential Justice. Joan Biskupic, welcome to Dialogue.
Thank you, George.
And let me thank you for this marvelous book. And we're going to discuss Sandra Day OConnor, who deserves many discussions in her own right, and certainly I'm sure with your help is going to be getting them this season. Speaking of this season, Joan Biskupic, I said in the introduction that this is a rather extraordinary beginning to a Supreme Court session, and I don't think that's overwrought on my part. And I've been reading others' opinions on it too, and they're using adjectives I wanted to see if you agree with. Not only is everyone saying it's a big time and big things are looming, but responsible commentators are saying things like it's a real watershed, and it has the potential to be huge. Now, do you describe to that degree of enthusiasm?
Well, the cases that are already up there are pretty significant, and I'll just name a couple. Mm-hmm. And the personnel is going to be different.
Right.
So the combination could be quite momentous. Mm-hmm. Let me just mention a couple cases
Certainly.
That your viewers would be interested in. An abortion rights case from New Hampshire, testing a statute requiring parental notification before a teenager has an abortion. And the question is, should there be a health exception, an emergency exception for young women who can't get that kind of notification out, and physicians who believe it needs to be done right away. Important cases having to do with the division between church and state, and a crucial case that was just heard recently involving assisted suicide, whether a state can have a law that allows physicians to prescribe an overdose to allow a terminally ill person to essentially end his or her life, whether the federal government can stop that. So we have many cases that are important, but here's where the real significance is. We have, for the first time since 1986, a new justice in the center chair, right. John Roberts, succeeding, as you mentioned, Bill Rehnquist. And then you also have the uncertainty over who will succeed Justice Sandra Day OConnor.
Right.
Now, George Bush has named Harriet Miers. We're just not sure how that's going to play out. And in the interim, this very crucial justice is sitting and hearing cases.
You know, that's as usual, Joan, thank you. I mean, that's the most succinct and yet powerful presentation of what we're facing. And we're going to talk about those cases you mentioned. And also the fact that the most influential justice, Sandra Day OConnor, the subject of your book, remains on the court. And as I understand it, Joan, she will, in that capacity, be, of course, a sitting justice. She'll be giving votes, her votes in conference and that kind of thing. But whether or not those votes count depend upon when she leaves, when her successor arrives and she leaves the court.
That's exactly right, and that's kind of confusing, I think, to the average person out there. Well, and it should be, because this is a very unusual situation. To have someone, when she announced her intention to retire on July 1st, she told President Bush that she would stay until her successor was named.
Right.
Now everyone thought, well, gosh, that should happen before the first Monday in October. Of course it didn't. And here she's sitting. She can cast a vote, she can listen to cases, she can cast a vote, she can actually even begin writing up opinions. But if Harriet Miers or someone else ends up being confirmed before that ruling is actually handed out, Justice O'Connor's vote is dissolved. And what happens is, if it's a 4-4 split, the case will probably be re-argued with the new justice on, Or if Justice O'Connor's vote wasn't crucial, they can hand down the decision.
You know, I appreciate that too, because I was thinking as I thought about it, what would happen if there were a tie? And as you say, they could re-argue the whole thing.
Right. In fact, if it were a split vote, it helps to re-argue it, because when the two parties to a case come to the Supreme Court, they want a resolution. And if you have a split vote, all that happens is the lower court ruling is affirmed.
Right.
There's no national precedent, but the lower court ruling is affirmed. And there's a lot of expense that goes into arguing a case. So I think the justices prefer not to offer a split vote and would rather have a resolution.
I think the people would agree with that. Now, Joan, your book is, of course, devoted to the person who's widely known or widely called the most influential justice. And she, Sandra Day OConnor, played an extraordinarily pivotal role and may yet play a pivotal role in the court in coming weeks. But you also credit her with, and here's the phrase, transforming the court more than any other justice of our time. And maybe the best way to start our focus on her is for you to explain that, Joan.
Well, I think her place in history was assured in 1981 when Ronald Reagan, for the first time, chose a female for the court.
Right.
You know, obviously we had nearly 2 centuries of history before we had a woman justice on the nation's highest court. So even by virtue of her sex and the appointment, she already was going to make history. But then what happened was that she got in there, sized up the institution, figured out how the brethren were working, and became a pivotal justice. And she did it in part because of the times. Several more conservative justices were appointed after her, and the court, like the nation during the 80s, 90s, and now, became quite polarized. Her strengths of searching for the center and consensus building, I think, played to the need on the court and the need in the nation at the time, for better or for worse. You know, a lot of people don't agree with some of the things she's done, but she's had power by virtue of the 9 members of the court and where the nation was, I think, during her 24-year tenure.
Was that role unprecedented, Joan, or did she just do it better than others had in the past?
Well, there are certain things that she had stronger suits in. For example, if you're talking about somebody who was quite strategic and quite effective as a author of opinions and securing a 5th vote, the first justice that would come to mind would be William Brennan. He was appointed by President Eisenhower, served for 34 years until 1990. He was a master at pulling 5 votes out of a hat, even when the conservatives came to dominate the bench, and he was quite a liberal. So she watched what he did, and she figured out a way to work behind the scenes and help craft consensus and get the kinds of opinions she wanted. So her role wasn't quite unique that way, and also her role as a pragmatist at the center echoed a lot of what Lewis Powell stood for,
right.
A Nixon appointee. But where she was different was that she came, I like to say, knowing how to count votes. She was the only member of this court who had been an elected state legislator during her tenure. So she had a political savvy, and also she had an interest in narrowly deciding cases at a time when that method prevailed.
Yeah.
So it was a combination of many factors that produced this unusual role.
You know, particularly that political career of hers, I want to delve into, because in the book, every reader who really gets into a book searches for that key to character, so to speak, and there are lots of keys to her character, but I want to focus on that. But before that, this question that just occurred to me, Joan, what was the Brennan O'Connor relationship like? I mean, because we're talking about people who had some things in common and yet maybe not.
That's a great question, because, look, William Brennan was born around the turn of the century. He was a man's man. He wore a brown fedora. He was a guy, he liked to link arms with Thurgood Marshall as they went through the hall. He always said, "Hiya, pal." You know, she was a different kind of animal to him. He also didn't hire many female clerks, which is surprising to so many people, because Justice Brennan was the author of opinions that really helped women's rights.
Right.
But he just, he was kind of old school, old-fashioned in some ways. And here she comes on. He's from urban New Jersey. He's Catholic. He's used to, he came up living in a household where the father was in the labor movement. He believed in government involvement. Here's Justice O'Connor from the West, a female, 25 years his junior. She was a little suspicious of him. His, I think some of her clerks and others who worked in the building felt that maybe she thought that maybe he might have been pulling one over on her at various points as he would round up votes. But boy, did she learn from him. And the relationship was actually quite cordial. He never sold her short. And I think that he early on realized that she was not to be dismissed and was a bit of a threat to him, as she was.
As she was. And I think for Justice Brennan and for everybody else on that court and everyone else watching, learning to work with her as a colleague, as a full colleague, must have been an education in itself.
It was, and you know, because she had faced discrimination and because she had been the victim of certain slights, she let those roll off her back. She didn't, if she held grudges, they were deep in her heart because people didn't see them. And she was the kind of person that if she received a note from somebody that was a put down, she never responded in kind. I found that very interesting as I read her correspondence.
I was moved by that in the book, that she wouldn't respond. At one point she got a very sarcastic, I guess many points perhaps, letter or comment, but she refused to do that.
Yeah.
Well, let's continue on the search for character, so to speak, and let's go back to Arizona. As I said before, I was really intrigued by the fact that she was the only justice, I think, who was elected to something.
Yes, during this tenure. I mean, we've had senators on the court and things like that before, but at least during her tenure.
For this court.
Exactly, exactly.
And let's focus on that because she was a state senator in Arizona. She was majority leader of the Senate, I think, in Arizona.
Yes.
And of course, the judge there. And so much can be said by that, but let me go to a comment from the book again that may bring us to focus on it. You describe her as an organizer of people and a synthesizer of facts. And that's back in Arizona. Is that the same thing that she brings into the court in Washington?
Yes, and even by now, when she shows up in '81, she's even more sophisticated. I use that reference at a time when she's still sort of learning the ropes of political grudge matches, where she's kind of caught off guard by some of the animosity that can emerge in politics. But she all along has had a great ability to organize things, to keep her fingers in several different disputes. And there are a lot of people who end up on the Supreme Court who have that efficient ability, but she more so than most. So she was able to kind of monitor where other wavering justices were on cases and really track things.
That's a politician's skill, isn't it, Joan?
Right.
I mean, to know where your votes are.
Yes, and to kind of figure out, okay, who do I work on behalf of here? Maybe I work on behalf of myself. There was that 1985 case where she helped Lewis Powell wrest the majority from Bill Brennan by monitoring what Byron White was doing. And, she did it in a subtle way, but the correspondence shows that she was doing it.
She was doing it, and she continued to do it. And here's something else that she did. The talents we're talking about right now, this is somewhat simplistic on my part to say they were purely political. I mean, this is a woman who's a child of the West, a daughter of a ranch. I mean, she's a very strong family. There are lots of influences on Sandra Day OConnor.
Right.
But I thought one of the most emotive and emotional brought forth in the book is the time she spent as a judge. And I want to go to a quote that, once again, I think encapsulates this whole chapter of her life and get your comment on the quote. She says, and it's kind of eloquent, "The whole experience of presiding over a trial in court is a remarkable experience. You see every kind of human emotion and human value expressed, and you see people in very tense situations. You listen in detail to some remarkable problems and situations of every kind. There are moments of great pathos in a courtroom, and there are moments of levity, and there are moments of boredom." I mean, that's the kind of rubber hits the road experience that has to influence justice at every level she operates at.
Yeah, she was really in the trenches, both as a politician. She learned how to work the back rooms, the smoke-filled rooms as they certainly were in the 60s. And then just sitting up there presiding over a lot of daily fare that happens in the nation's courtrooms. Check-kiting cases. You'd have that. You'd have assaults and batteries. She did a lot of hands-on sort of law as a judge before moving to the rarefied world of appellate law, which is what we have up at the Supreme Court.
Right. And I'm just going to quote one thing you just brought back to my memory. And one, I think it was check-kiting or check fraud or something. There's a perhaps young woman, a woman before her with children who's been guilty of some kind of check offense, and she has to sentence her as a judge. She gives her 10 years because that's what's called for, and that's what the woman's crime seems to deserve. Then she goes back in chambers and cries. I mean,
Yeah, in fact, that story was told so many times I almost didn't believe it, and I thought at first it might be supporters of Sandra Day OConnor trying to put a more human face on her, to say that this woman who presents herself quite severely on the bench in Washington broke down in tears when she had to sentence this mother. In fact, the dialogue in the courtroom back in Arizona, and this was in the 70s, was, you, Miss Defendant, you're a beautiful woman, you have a supportive family, you have 2 lovely children, and look at what you've done. And she gives this woman a very harsh sentence, and then it goes back to her chambers and collapses in tears. But I found so many people saying, yes, that indeed did happen. And what I found throughout is that there were many very personal times for Sandra Day OConnor that contrast to this really tough presence that you see day to day at the Supreme Court.
Right.
Lawyers, she gives lawyers a real run for their money.
Right.
But as Justice Antonin Scalia said to me at one point, she's a real softie.
Yeah, well, she struck me as a person of a great self-control, but like many people with great self-control, a powerful emotion as well.
Right.
I mean, they sort of go together. Now, a moment when great self-control and powerful emotion and a test for the country and a test for her all come together, Joan, and a word with which she will forever be identified is abortion, and particularly the abortion case that comes before the court in 1989. The first woman justice on the court, and she's at the center of everyone's eyes on this. Interestingly, I got from the book the impression that prior Chief Justice Berger and Justice Blackmun, deeply impressed with her, thought that she was going to be a solid vote for overturning or curtailing Roe versus Wade. In the end, she doesn't do that.
She gets to the brink and she steps back.
Yeah.
That was a fascinating term. That was also the term that she discovered the breast cancer.
That's right.
And had to undergo a mastectomy and chemotherapy. It was a very difficult term. A lot of tough cases and a lot of deep personal experiences for her. What happens is that at this moment, William Rehnquist has become Chief Justice, and he thinks he'll have her 5th vote to seriously curtail Roe versus Wade. And she waits until just about the last week of working on the case and writes a concurring opinion that she circulates to the fellow justices that backs away from some previous criticism she had voiced about Roe versus Wade, which is the 1973 ruling that made abortion legal nationwide. And she has a statement that says, in effect, there may be time to reconsider Roe versus Wade, but that time is not now.
Right.
And I talked to Ruth Bader Ginsburg, who at the time was an appeals court judge. She, in 1993, ends up on the Supreme Court. But she said when she read Justice O'Connor's opinion in the Webster case from Missouri that you referred to, she felt that it was a turning point for Justice O'Connor.
Wow.
That it was, even though the public didn't quite see it at the time, because she essentially was still upholding these Missouri restrictions on abortion, but her language, her tone was a step back from where she had been before. And then lo and behold, in 1992, she is one of the pivotal justices who votes and writes that Roe versus Wade should be affirmed.
Yeah, it's very interesting. It's interesting as a case of human growth and development as well.
Right.
Well, Joan Biskupic, as I'm sure you'd agree, here we are now in the Roberts Court in the year 2005, and abortion is still with us. And as you said earlier, parental notification case is coming up this session with Justice Roberts presiding. To cut to the chase on this, and so much could be said, but what kind of challenge is this going to be to him? Because I think this case is, if I understand it, federal authority versus state authority. That's the core question?
The core question here is the health exception when you have an abortion regulation.
Right.
Do you have to have a health exception for women? But a trickier question, but actually more consequential question, and bear with me because it actually involves legal standards of looking at abortion cases, is what standards should any lower court judge use when faced with a challenge brought by a class of people against an abortion regulation?
Right.
Do individuals who will actually be affected by the abortion regulation have to come forward, or can it be sort of struck down or addressed as a facial matter? It's a legal technicality, but it has great consequences, because what happens is this New Hampshire case, the law that doesn't have any kind of health exception, has been challenged by a Planned Parenthood from the region. And what the Planned Parenthood group says, and what other courts have affirmed, is that it should be able to challenge it as kind of on its face and say it wouldn't be constitutional in any case. And what New Hampshire is saying, and what the Bush administration has endorsed, is a line of argument that would say, no, you can only address this case with individual women here and here and here and here.
No
well, that's That's more difficult. That actually makes it harder for challengers to abortion statutes to get into court, and it could create a piecemeal situation. As I say, it sounds technical, but it's actually quite consequential. And this will be the first challenge that John Roberts will have to show his hand. It will be argued in late November. Now, will Sandra Day OConnor be sitting then? We don't know.
We don't know.
Right.
But I like that phrase, the first chance he's going to have to show his hand. Now, as someone who covers the court, Joan, you'll be looking at other things as well. Many things I know. For example, the number of cases they decide to take. Won't that be an indication of the Roberts course?
Well,
or the way he runs the conference sessions? I mean, there's a lot of stuff that you'll be...
There's so many different ways that a Chief Justice can be measured, and he told senators during his hearings that he thought that the court should be taking more cases. The justices have actually reduced the number of cases they're taking in hearing over the last 2 decades.
Down to 74 now.
Yes, and at one point, actually around the time that John Roberts was clerking, it was up to close to 150, twice the number. And John Roberts told the senators, I think we should be deciding more cases, or I think the Supreme Court should be deciding taking more cases. But, you know, he can't do that on his own. Yeah. It takes 4 votes to hear it. And I think they're kind of comfortable up there with that workload.
So I would be, or much less.
Right, so we'll see. We'll see. But now, in that position, first of all, he's been quite active during oral arguments, but he's the one who starts the conferences with the other justices, and these are done in secret. But the word has leaked out that they've been quite impressed by him.
Right. Joan, you know, the other big thing that's going to come up, at least guaranteed to come up, is the assisted death case in Oregon.
Yes.
And this, of course, is I think I might have been wrong on the earlier parental notification case in terms of federal state, but this is where federal state.
This is exactly right, George.
And this is where his own personal beliefs, I mean, everything's going to be watching, are going to be tested, in a sense, right? Right,
and I think he already tipped his hand a bit during oral arguments because he seemed to be quite sympathetic to the federal government's anti-drug effort. And that's what the federal government is saying. Look, we have controlled substance laws, and we don't think that physicians should be able to just prescribe overdoses that would help an individual who's terminally ill and his or her death. And this was a pet project of Attorney General Ashcroft. He had wanted to stop assisted suicide that was approved by Oregon voters. And the Bush administration has continued that crusade, and Chief Justice Roberts seemed to indicate that he frowns on Oregon's effort.
Joan, as you know, this is also a foreign affairs program, and the Supreme Court, people, I certainly have come to understand this, the Supreme Court has really a very powerful role in the foreign affairs activities of this country. Let me see if I can fold 2 things together in one question just to get some sense of it. They're 2 kind of disparate things, I'm afraid. One is something called comparativism. The degree to which American judges and justices, too, on the Supreme Court have been citing foreign law as precedent for their decisions. And the second is something cited by a columnist, and that is the degree to which presidential power, particularly in the imprisonment of foreign nationals and so forth, is becoming a major issue. Now, here's your challenge, Joan. Can you give us a sentence or 2 on that?
Let me tell you what this is all about. Of course, throughout the international scene, we'll often cite the law of other countries. Typically, though, it's only to inform an opinion. It's not to base it on some other country's law. And that's just exactly what's happened with the Supreme Court, although it's increased. What this Supreme Court does will often look to international law, will often look to European law, especially, just for guidance. It's not to say what our Constitution says, but here, let me give you an example of how it came up. In the juvenile death penalty case, and in the death penalty involving the mentally retarded, the justices looked at what was going on the international scene. They didn't say, oh, because these many countries forbid execution of juveniles or forbid the execution of the mentally retarded, we should do it too. It was more that they said, look, this is what our Constitution says about evolving standards of decency, and this is how we can also look to see what's been happening internationally. But that has really riled conservatives, mostly because these opinions where international law is cited tend to go in a more liberal direction. I have a feeling that if it were going in a more conservative direction, we wouldn't have this outcry from people like Tom DeLay in the House of Representatives complaining about this. So this is an issue, and it came up in John Roberts' hearings, and he didn't say he'd definitely go against it, but he did say, you know, look, it shouldn't decide a case, but lots of things can inform a case.
Right.
Yeah.
Joan, and that was wonderful, because now I think I do understand it a lot better than I did. And the presidential power notion, do you think we'll see a lot more cases like, the Guantanamo cases and that kind of thing, I guess?
Right. Well, right now there's a case pending before the Supreme Court that could be acted on over the next month, having to do with the military tribunals. Lower courts have a key lower court where John Roberts was sitting, actually, before he became a justice, upheld the president's order involving military tribunals, the trying of detainees at Guantanamo Bay. A lawyer for one of the detainees there who's been charged has appealed, saying that there are not adequate constitutional safeguards with these military tribunals. So now it's in the hands of this U.S. Supreme Court to say whether it will take up the case or it will wait until after these tribunals have actually occurred and gone through the processes. It's kind of at an early stage, but there you have it. That's a key answer to your question about presidential power, because that's what this revolves around.
Right. I guess the answer to that is stay tuned, right? Because,
right. We'll know in about, I would say, as soon as 2 weeks, whether they'll take the case, and if they just send it back, then the tribunals essentially get a green light for now.
Joan Biskupic, it's always wonderful to talk with you. And as we come to the conclusion of this conversation, there are going to be lots more. I can tell you that, because it's always a delight, and I always learn. Let's return to Sandra Day OConnor, and in the context of all we've been talking about in this particular moment, because anyone as formidable and as great as she has been leaves what we can only call a legacy. Now, I know this question may sound a little trite, but I think it's important. What is that legacy, and how is it best preserved? And once again, maybe perhaps in a sentence or two.
Okay. As the first woman, school children throughout the globe will know of her. And there's hardly an area of life that she hasn't touched. Abortion rights, affirmative action, the death penalty, the division between church and state. She had a key role.
That's wonderful. Joan Biskupic, thank you so much for this conversation and for this book.
Thank you, George.
Enjoyed it.
Thanks.
And that's our program. We appreciate your comments, and you can reach us at dialogue@wilsoncenter.org. I'm George Liston, CA, and you've been watching Dialogue, a co-production of the Woodrow Wilson International Center for Scholars and MHC Networks. Please join us again right here next week, and thank you for watching. And thank you, Joan.